All right, I think we're going to get started. For those who don't know me, I'm Nick Vlietstra. I'm a partner in the Finance and Restructuring Practice Group. Today's Bank Counsel Roundtable topic is Banks at the Supreme Court, which is being presented by Tim Droske and Mike Stinson. Tim Droske is on my right. Tim is co-chair of the firm's appellate practice group. In addition to his work on banking-related litigation and appeals, Tim has an active U.S. Supreme Court practice, which includes firsthand experience successfully petitioning the Supreme Court for review, writing winning merits briefs, and filing numerous amicus briefs to the Supreme Court at both the petition and merits stages. On my left is Mike Stinson. Mike's a partner and trial lawyer here at Dorsey who practices primarily in the areas of banking and financial services. His banking litigation experience runs the gamut from individual wrongful foreclosure or quiet title cases to nationwide loan servicing and Ponzi scheme class actions. Thanks for coming today, and I'll hand it over to Mike and Tim.
Thanks, Nick, and thanks everyone for coming on this Friday afternoon and everyone tuning in remotely as well. So before we start going through some of the different specific cases that are before the Supreme Court this term, as well as some other cases that are kind of percolating up through the Court of Appeals, we thought we'd first spend a few minutes just giving kind of an overview of the Supreme Court this term. As we all know, it's a new court with a new composition. Justice Kennedy's retirement at the end of last term created the vacancy that Justice Kavanaugh filled after it was one of the most contentious confirmation hearings that we've ever seen. And there was either a lot of dismay or excitement, depending on your political leanings, about the potential of this kind of conservative block of five being able to usher through kind of a conservative agenda on the Supreme Court. And for better or for worse, depending on your perspective again, so far that hasn't really happened. And we can spend a few minutes talking about that. One of the main reasons for that is Chief Justice Roberts. Since Kennedy's retirement, he's kind of become the new swing justice. And while there's really no indication that his conservative ideology has weakened at all, it has become increasingly clear that he's first and foremost an institutionalist who's really concerned about how the court is going to be perceived as an institution. And so particularly in these kind of hyper-politically polarized times, he's really spoken out to try to, and in his votes as well, you see that he's really trying to take a very active role in maintaining the court's reputation as being kind of an independent third branch of government. He made remarks here at the University of Minnesota Law School back in the fall. They were his first public remarks after Kavanaugh's confirmation, where he made clear that judges and justices aren't politicians, that they're answerable to the Constitution, not the different political forces that are out there. And he also, publicly spoke out against President Trump when he made a reference to Obama judges. So Chief Justice Roberts has very much been a swing vote. And in fact, if you were to look at who he's voted most in alignment with so far this term, it's actually most in line with Kagan, Sotomayor, and Ginsburg. So, we're only about 20-some cases into the Supreme Court's term, but so far he's certainly proven to be a swing justice. And Kavanaugh himself hasn't been the conservative firebrand from the bench that some people were expecting. His strongest voter alignment right now is actually with Breyer. He's agreed 100% of the time, again, in the 20-some cases that have been issued so far with Breyer. So no reason to necessarily think that that's going to play out long term, but at least in the early stages of this term, that's what we've seen. So while there are new faces on the court, some things never change. Justice Ginsburg is still going strong. She turned 86 this past month, and despite being hospitalized for broken ribs after falling and needing to miss some oral arguments, and then in the course of that hospitalization, they saw some potentially cancerous growth. She had to go undergo lung surgery. As of mid-March, she was actually the justice who had written more opinions and published them at this point than any of her other colleagues on the court. So 86 is young when you're a Supreme Court justice. Another thing that has not changed is there are still no cameras in the courtroom. This comes up periodically, that there be greater transparency and that in this modern age, there's no reason that there can't be a camera live streaming oral arguments. But notably, just this past month, Justices Kagan and Alito both testified before a congressional subcommittee and said that they firmly supported the Chief Justice in the fact that there should not be cameras in the courtroom, that it would change the way that advocates advocated at oral argument. It would change the way that the justices asked their questions and interacted, and they both admitted that it would have negative consequences, and both also admitted that or at least Alito did, that was a 180 in his own perception, between when he was not on the court and now being a Supreme Court justice. So while those things never change, one thing that has changed is we learned this past term that Justice Thomas does speak. So just earlier this past month, he asked questions at oral argument for the first time in 3 years. The last time had been in a gun rights case soon after Justice Scalia had died. And prior to that, it had been like a decade. And, and he's given different talks about, very well-reasoned views for why he doesn't normally ask questions, but it's always exciting when he does it. It kind of reminds, I don't know if anyone's familiar with like the Mr. Bean character, the British comedian, who does all these like silent comedy bits, but then like once in a movie will open his mouth and everyone just like, is really excited to see what he might say. And so for the one and only audio-visual clip we have here, here's the 30 seconds in case you didn't hear it.
Unless this court has further questions, I will waive rebuttal.
Ms. Johnson, would you kind enough tell me whether or not you exercised any peremptories?
I was not the trial lawyer.
Well, were any peremptories exercised by the defendant?
They were.
And what was the race of the jurors struck there?
She only exercised peremptories against white jurors. But I would add that her motivation is not the question here. The question is the motivation of Doug Evans.
So in another 3 years, you might get another 30-second clip. So now we'll start going into some of the different cases that are banking related that are before the court. The first is a class action case, Frank v. Gauss. And the underlying facts aren't banking specific in any way, but the class action issues that were before the court are ones that are going to arise very frequently in banking related class action litigation. The issue that went up to the Supreme Court was the propriety of cypre settlements. And the facts that got the court there was that you had 3 named plaintiffs who sued Google for alleged violations of the Stored Communications Act. This is a federal act that says that certain private information can't be sent through the internet. And these named plaintiffs said that the way that Google search worked was that it was, improperly violating the statute by sending certain information along. They had a putative class of 129 million individuals. The Stored Communications Act has a private right of action. And the case settled. Here's the agreement that the parties agreed on was that 5 million would go to cypre recipients. So these are organizations that have some sort of, public interest bent that's somehow related to the class. So it was going to a lot of like law schools that had some sort of like law in the internet clinic. It went to the AARP, some of the funds did. 2 million went to class counsel. And the key fact here is that no money went to the absent class members. Of course, if you were to divide 129 million, 5 million by 129 million, you would get about 4 cents a class member, which is the reason that this was a cypre settlement. The appropriateness of that settlement went up to the Ninth Circuit. And what they said is, the general rule is that a cypre-only settlement isn't preferred, but they acknowledged it can be appropriate where the settlement fund is non-distributable because the proof of individual claims would be burdensome or distribution of damages costly. And they said that that standard was met here. What they didn't address at all was the named plaintiff standing, even though the Spokio decision from the Supreme Court, which I'll talk about in a second, came down while the case was pending before the Ninth Circuit. So the sole question that the Supreme Court granted review on was whether cypre settlements are appropriate under Rule 23. But when the case got to the Supreme Court, the Solicitor General, in its brief, raised the question of whether the named plaintiffs here even had standing under Article 3 to sue under Spokio. So as a refresher, the Spokio decision came out in 2016 from the Supreme Court, and what it dealt with is when you have a private right of action under a federal law, does a plaintiff have standing solely by virtue of the fact that that statutory provision was breached by a defendant? Or under Article 3, do they need to show that some sort of individualized injury beyond just the fact that the statute was violated? What the court ended up doing here was issuing a per curiam decision, kicking the case back down to the lower courts to decide whether standing exists here under the Spokio standard. So again, even though there was an alleged violation of this federal statute and a private right of action, had any of the named plaintiffs actually had any sort of individualized harm by however Google search worked? Here are some things that are significant about it, I think, in terms of banking class action litigation. The decision emphasizes that the courts have their own independent obligation to ensure standing exists, including in the context of a proposed class action settlement. What this means is that a class action settlement isn't just going to be rubber stamped by the court. And we know that there are various reasons why that doesn't happen, but the Supreme Court's really emphasized that standing by the named plaintiffs needs to be another thing that the courts need to look at independently of whether it's raised by the parties or not. Another key thing is that standing is another important arrow in defendants' quivers in challenging a class action lawsuit. And the way that Spokio issues are going to arise in the banking context, one that stands out and has been litigated is how that applies in data breach cases, for example, where someone's credit card information was stolen, but if it hasn't been used in some way, has there really been an individualized injury? On the flip side, it could also make global settlements more difficult. There are certain times where you may be negotiating a class action settlement with plaintiff's counsel, and there's an interest in making the class broader just so you can kind of get global peace. And sometimes you'll have the plaintiff say, I know we can find another named plaintiff for whatever extra subclass you may want to try to bring into the settlement. They may have a person, but that doesn't mean that person's going to have standing. And again, the court may conduct their own independent review of that following this decision. There's also the remaining question of the propriety of cypre settlements going forward. Oral argument was heated with strong divisions from both sides of the bench in terms of whether they're appropriate or not. Justice Thomas wrote separately to make clear that he does not think that cypre settlements are appropriate under Rule 23. And one other thing to keep in mind is during oral argument, questions also came up that kind of implicated the appropriate of claims made settlements. The underlying question here is, is there a meaningful pot of sum that can be distributed to the class members as opposed to going to cypre recipients? In terms of how that pot could otherwise be divided, questions come up in terms of, are claims made settlements another alternative, and are those appropriate as well? So those are just all things to keep in mind as you move forward in litigating these cases and settling them.
Thank you. So the next case we're going to talk about is the Droske v. McCarthy and Holthus LLP. This is a case that went up to the Supreme Court and was decided in the fall of 2018. It's a Fair Debt Collection Practices Act case, which might be of interest to some of you. Although I think the FDCPA stuff comes up, in my experience, it's come up a lot with law firms who are foreclosure counsel, and that's exactly what happened in this case. The question or issue in this case was whether a law firm defendant who had instituted non-judicial foreclosure proceedings against the plaintiff mortgagor was within the definition of a debt collector under the FDCPA. So the FDCPA only applies to, obviously, debt collection and debt collectors. It defines debt collectors, has a primary definition and a definitional section. And under the FDCPA, a debt collector is primarily defined as any person in any business, the principal purpose of which is the collection of any debts, or who regularly collects or attempts to collect directly or indirectly debts. So I think to simplify the question that was at issue in Droske is someone who's engaged in the non-judicial foreclosure business, engaged in the business of collecting debts. And there's two viewpoints, I suppose. The viewpoint that prevailed ultimately is the answer is no, that a mortgage, the argument that was made is that foreclosing on a mortgage or enforcing a lien is not necessarily collecting a debt, that a debt is distinguishable from a lien or property interest. Although that argument was advanced, I think that the court kind of took that head on and said that's not really the basis for our holding, the Supreme Court holding, that really it's more textual based on the statute itself, because there is this other definitional provision of the Fair Debt Collection Practices Act that says, this is at 1692 F6, says the term debt collector also includes any person in any business, the principal purpose of which is the enforcement of security interests for the an antecedent for the purpose of section 1692 F6, which is a very narrow and limited section of the FDCPA. And textually, this provision, ultimately, this is really the primary basis for the Supreme Court's holding that that non-judicial foreclosure is not included within the primary definition of a debt collector, that this carve-out, if you will, would be superfluous if persons engaged in the business of enforcing liens or in the primary business of enforcement of security interests were already included within the definition of a debt collector, then this provision would be unnecessary. That's the primary basis for the court's holding, the Supreme Court. And this is the holding below that was in the DC circuit, I believe, that we're looking at this slide. Yeah, so actually this was argued in the fall, so it was a very recent decision, just came out like last week, actually. And I think I think I may have forwarded it to a few people when it came out, but so there's really three bases for the court's holding. The first is, we've already talked about the textual basis, that the carve-out at 1692 F6 would be superfluous. The second basis is that the court's interpretation, if the court were to hold that the persons who are enforcing security interests are debt collectors generally, and therefore subject to all of the provisions of the FDCPA, that would be impractical and impossible, frankly, because there are all these statutory regimes for non-judicial foreclosure that would violate the FDCPA if lawyers were subject to the FDCPA, or law firms who are engaging in non-judicial foreclosures. For example, debt collectors cannot advertise or make public or disclose certain information about the targets of the debt. And by definition, non-judicial foreclosure proceedings often involve public advertisements. And so that would constitute a violation, arguably, of the requirements of the Fair Debt Collection Practices Act if, in fact, lawyers or law firms or whoever's in the business of enforcing these security interests were debt collectors generally. And so that's just not practical. That's the second basis for the holding. And then the third basis for the holding is legislative history, which, I think it's a little counterintuitive to me as I read it, but I think this is pretty common, kind of like a belt and suspenders approach, but that obviously the court had already held that the text was plain and unambiguous, and so I didn't necessarily understand why we were getting into legislative history, but they did. And it is pretty persuasive that there were prior versions of the definition in the FDCPA defining the term debt collector that did include those enforcing a security interest, and that changed and evolved over time to exclude, or no longer include is probably more accurate, no longer include persons engaged in the primary business of enforcing security interests. And so the court found that persuasive, that Congress intended for non-judicial foreclosure proceedings to be limited. One thing, there was, I believe, there was a concurrence. Sotomayor had a concurrence. It was a unanimous opinion, but there was concurrence really just to express, I think, some caution and concern that the holding of the court was not, a blanket or shield for, for law firms or persons who are engaging in non-judicial foreclosure to run amok, if you will, of the FDCPA, because there is still that narrow provision that'll apply, and there are obviously other laws that will apply. So it's not just a blanket holding that those engaged in the primary business of enforcing security interests are never subject to the FDCPA, even the other provisions of the FDCPA, that she tried to clarify that it's intended to be a very narrow holding, so it couldn't be used later for more broad purposes.
Moving along to another case that factually has nothing to do with banking, but could actually have real big ramifications for the banking industry, is Kaiser v. Wilkie. And this puts our deference in the crosshairs, a fun word to pronounce, and is kind of the precursor to what might be the big showdown in the future about Chevron deference. So a quick just reminder of what these doctrines are. These involve administrative agency regulations and how courts, and if courts are required to defer to them. The Chevron rule was one that Justice Stevens promulgated in the Chevron case. And the principle there is that if Congress has passed a statute and delegated authority to an agency, if there's any sort of ambiguity or lack of clarity in the statute, then the agency can promulgate regulations, and those regulations on that issue of ambiguity are entitled to deference so long as it's a reasonable interpretation. So you have the Article III courts deferring to the administrative agency's view. Our deference is the same thing, but just one level down. That when an agency has promulgated, regulations that appear in the Code of Federal Regulations after formal notice and comment rulemaking, that if there's ambiguity in those regulations, the agency can then offer its interpretation of that term, and that interpretation is likewise entitled to deference so long as it's reasonable. So the specific context for this case was involving the Department of Veterans Affairs. A man applied for benefits, and you can see here that it's a regulation in the Code of Federal Regulations that's at issue. The Veterans Administration will reconsider a claim. So if a claim had been denied for benefits, they'll reconsider a claim if it receives or associates with the claims file relevant official service department records that existed and had not been associated with the claims file when the VA first decided the claim. The issue here is what the term relevant means. According to Kaiser, he said relevant means anything that pertains in any way to the overall decision of benefits. And so he brought new evidence that he had post-traumatic stress, and the Veteran Administration said, well, yes, that's related, but it's not relevant to the earlier reason that we denied your claim, and that's what relevance really getting at. And so the Veteran Administration's view is, the new information to be retroactive and relevant needs to specifically pertain to the underlying basis that the claim had previously been denied. None of that really matters here. The key issue is whether the term relevant is ambiguous, and if so, whether the Veteran Affairs Court's interpretation is entitled to deference. The Federal Circuit, it applied our deference. So as a general rule, we defer to an agency's interpretation of its own regulation, as long as the regulation is ambiguous and the agency's interpretation is neither plainly erroneous nor inconsistent with the regulation. It found the term relevant was ambiguous, and the Veteran Administration Court's interpretation was reasonable. And so it upheld the Veteran Administration's view of it. So you can see, even though this is Veteran Affairs, the broader issue is one that sweeps everywhere. You have various, you have the Dodd-Frank Act, and then you have regulations promulgated pursuant to it, and then you have agencies that are interpreting its own regulations, and the question is, who decides what those mean? Is it the court, or is it the agency itself? One thing that's notable is how the question was framed in the petition for a writ of certiorari that was granted here. So when you're petitioning the court for review, you get to decide how you want to frame the issues, and there's a lot of strategy that goes into that. And normally the court grants review on the questions as they were presented. Here there were two questions presented. The court only granted certiorari on this one, which was pretty in your face, whether the court should overrule our and kind of a related case, Seminole Rock. So there was no effort to kind of tiptoe around the fact that it was asking the court to overrule its past precedent. We don't have a decision in this case yet, but oral argument occurred just this past Wednesday. So I was able to look at the transcript. The audio is now online, probably now. It wasn't earlier today. And you had a deeply divided court based on the transcript and what court commentators were saying. Justice Breyer expressed his view that eliminating our deference and putting interpretation in the hands of the judges and justices, to him, that this sounds like the greatest judicial power grab since Marbury v. Madison. And he was kind of quick to point out, Marbury v. Madison was a good decision. This kind of judicial power grab would not be in his perspective. And he raised examples. I mean, he was, bringing up kind of esoteric terms that, the Environmental Protection Agency has to interpret, and says, I don't know anything about these terms. And then you'd have Chief Justice Roberts chime in and say, well, I'm even more confused as to what our deference means than what that, environmental term may mean. So from the four liberal justices, it's clear that they're in favor of kind of the status quo, which is agency deference. One thing that kind of underlies this case as well is, again, when the question presented was that, that bold and just asking the court to overrule its own past precedent, there's concern from, in light of the fact that you now have a 5-4 court, there's concern from the more liberal members of the court that, okay, if we start overruling precedent like this, what's the other precedent that may be overruled down the road? And you saw Kagan kind of speak to that in one of her comments. She said to counsel, we take it super seriously when we do overrule a precedent. And then said, well, we used to, because even last term the court overruled a prior decision in First Amendment union fees, in a union fees case, reversed itself on internet taxation, for example. So, that's a bigger issue that underlies this. In terms of where this is ultimately going to go, again, like I said earlier, it's the Chief Justice and Justice Kavanaugh who seem to kind of have the deciding votes here. Chief Justice Roberts seemed to indicate, our deference has really been carved down to a pretty narrow category. Maybe we can just let it kind of have its own real small cabined off spot as opposed to overrule it completely, even though he's expressed on prior occasions his discomfort with our deference. Kavanaugh has previously made comments that he could see kind of Chevron and our be overruled, but he was also somewhat measured. I mean, he emphasized that, that there should be some sort of kind of formal notice and comment rule-making process when an agency is going to be interpreting its own regulations. But he wasn't as bold as, let's say, Justice Gorsuch from the bench in kind of condemning the whole notion of agency deference, deference to agencies by courts. So it remains to be seen, but again, this will have big ramifications for how cases are litigated, how statutes are interpreted if Chevron gets overruled, and again, to what extent any of the regulatory bodies over the banking industry can receive deference for their own interpretations of ambiguous phrases, or whether it's the court who ultimately gets to make that decision.
The next case is Rotkiski v. Clem. This is a case that was decided in the Third Circuit, another FDCPA case, and it's a really simple one, actually, I think. It's a statute of limitations case. The facts are that the plaintiff had accumulated a credit card debt of around $1,500, and his bank referred it to a debt collector, Clem and Associates. Clem sued for payment and attempted service at the plaintiff's last known address, where the plaintiff borrower no longer lived. And so they gave up for a while. That was in March of 2008. And when they couldn't locate him, they withdrew their lawsuit, and they seemed to give up. And then they decided to try again. And they, for reasons unknown or that are unclear, they tried to serve him at the same address that he no longer lived at before, like that he really liked the place and was going to move back or something. And just sentimental value, a lot of good place. And of course, he didn't live there. And whoever did live there, though, said, oh, yeah, I'll accept service on his behalf. And they did. That's what they did. So he got served, I guess. Unbeknownst to him, somebody had accepted service who was unauthorized at a place that was not his residence. And then Clem and Associates took it a step further and got a default judgment when he didn't answer. And he found out about it in September of 2014, and the judgment came in 2009. So 5 years later, he finds out that these guys did this, and so he sues them. In addition to, he sues Clem and Associates, and he sues some other folks. I imagine maybe the process server or something, I don't know, and maybe the person who accepted service. But more integral to the decision, in his lawsuit against Clem and Associates immediately moved to dismiss under the statute of limitations of the FDCPA. And the FDCPA says that, quote, an action to enforce any liability created by this subchapter may be brought in any appropriate United States district court within 1 year from the date on which the violation occurs. So that seems pretty clear to me that that it's speaking in terms of the violation. It's not speaking in terms of discovery of the injury or the damage, no matter how unfair the result might seem or be. But the Fourth Circuit Court of Appeals and the Ninth Circuit Court of Appeals have both held that the discovery rule applies, despite this language, that a claim does not accrue for purposes of the statute of limitations under the FDCPA until an injured plaintiff or creditor, or I'm sorry, debtor, knows or has reason to know that that they have a claim. The Third Circuit affirmed the dismissal from the district court, and then sua sponte and took it en banc and affirmed it again, which I've never really heard of, I guess. that they would sua sponte, take it en banc to affirm it. And that's what they did, and they disagreed with and they addressed directly the reasoning of the Fourth and Ninth Circuits, specifically the Ninth Circuit. So the Ninth Circuit Court of Appeals, they really didn't address too much the actual language of the statute, which seems important. You know, I don't know much about this law stuff, but that seems important. And instead, they relied on a prior Ninth Circuit decision that holds basically very broadly that federal statutes or federal causes of action, that the discovery rule applies to all of them, which seems like a bad holding, if that's in fact what it is. But, and in fact, the Supreme Court has cited that very case from the Ninth Circuit and said that that's wrong, and yet they persisted. It's kind of interesting. The Third Circuit kind of has a funny quote, I thought, like they quote from the Ninth Circuit. The Ninth Circuit, what does it say? Most fundamentally, neither the Fourth or Ninth Circuit opinions analyzed the, quote, violation occurs, quote, language in the FDCPA. In Mangum, the Ninth Circuit did not engage the text of the act, relying instead on its expansive holding in Norman Bloodshaw v. Lawrence Berkeley Labs that, quote, the discovery rule applies to statutes of limitations in federal litigation, period. The Ninth Circuit did acknowledge that the Supreme Court had reversed its application of the Norman Bloodshaw rule to the FCRA in TRW, a Supreme Court case. Nevertheless, after brushing aside TRW's analysis as, quote, food for thought worth musing on, the majority of the panel in Mangum concluded that TRW neither overruled nor undermined the circuit's prior precedent regarding the general applicability of the discovery rule to all federal claims, even though the Supreme Court held that a federal claim was subject to the occurrence rule. But I thought that language, food for thought worth musing on, was good.
So neither the language of the statute nor Supreme Court precedent is
It's the Ninth Circuit.
yeah,
Right, so they just kind of have a mind of their own. Anyway, so not surprisingly, the Third Circuit en banc, of course, they hold that the language of the statute's pretty clear. The occurrence rule applies. They say it doesn't need to say that the occurrence rule does not apply in haec verba, which is Latin for in these words or verbatim, which I didn't know. I thought I'd drop that nugget on you guys. I thought that might even be the most important lesson today, is that quote. So there you have it. All right, next one. So now I got to go back to back. I didn't realize I had a mic drop moment. So the next case is SFR Investments Pool 1 LLC v. Federal Home Loan Mortgage Corp. This one is really, I think at its core, a preemption holding. There's a lot of stuff kind of mixed in here. I think I picked it because it has the enterprises and deals with the Federal Housing Finance Agency and Fannie and Freddie. But it kind of touches on a lot of things more broadly, but some of them are pretty banking related. So in this case, there were liens for unpaid homeowner association dues that were foreclosed on in Nevada. The homeowner association sold 5 properties to SFR Investments Pool 1 Inc. Fannie and Freddie had purchased and securitized mortgage loans encumbering the properties. Fannie and Freddie were subsequently placed under conservatorship by operation of the HERA, and so FHFA is the conservator. And then there's the federal foreclosure bar that basically says that if the Federal Housing Finance Agency has a an interest in a lien that it can't be foreclosed on or wiped out without their consent. And at issue was, so they foreclosed the HOA sales, they foreclosed on the property and purported to extinguish their lien that they had acquired as conservators, or as conservator to Fannie and Freddie. The Nevada's Foreclosure Act provides that foreclosure of an HOA super priority lien quashes all other liens. And so that was in conflict, obviously, with the federal foreclosure bar. And so Fannie and Freddie and FHFA sued SFR Investments Pool 1 LLC for quiet title. The Ninth Circuit held that that there's preemption, effectively, and that the federal foreclosure bar does apply. There were some arguments made that, frankly, I didn't quite understand fully, that talked about succession versus trust. So whether or not the conservator succeeded to into the shoes of Fannie Freddie in its status as conservator versus holding the loans as a trustee, and whether the capacity in which they hold the loans, the FHFA makes a difference for purposes of application of the foreclosure bar. From what I could tell, that did not matter, and that they held that that they succeeded in any event, no matter what, because they still had an interest, and that term was very broad, and that's really under the federal foreclosure bar, that's really the test, is whether they had any interest at all or right in the mortgage, then it can't be extinguished. So they've filed a petition for cert to the Supreme Court very recently, March 25th. I think that was Monday. The reply in opposition was filed. They've framed the question as being very dramatic, that it applies to millions of mortgages nationwide. So we'll see if cert is granted. Seems like there's a lot of preemption-related cases that are being considered right now. That seems like kind of, maybe there always are, but seems like right now there are. So that's that one. And the third one in a row is this Luznik case. This one we were kind of considering keeping out. It's another preemption case. This one, though, deals with the National Bank Act. And in fact, this one was, I think, one that was very closely watched for a while. There was interest in whether the Supreme Court would take it, and they did not. The Supreme Court denied cert last November. But this one was one, I think, that was being watched pretty closely at some of the banks. And the case involved, it's from the Ninth Circuit again, a lot going on there. But the case involved whether the National Banking Act preempted a California statute that required banks to pay 2% interest on escrow to mortgagors, or a 2% return on their amounts in escrow. And Bank of America said, whoa, that's preempted. That's within the purview of the Banking Act. And the Dodd-Frank Act expressly, I think, codifies or the common law principle that if it has a significant impact, right, the Barnett Bank principle, that any state regulation that prevents or significantly interferes with a national bank's exercise of its powers is preempted by the NBA. And that standard in Barnett was expressly codified in Dodd-Frank. The Supreme Court has yet to consider or address that language from Dodd-Frank and the scope of its effect. So people were real excited about the Luznik case because they thought, okay, this is going to be the first one where the Supreme Court's going to chime in, but then it didn't. So I guess what's interesting about it from the bank perspective is that everybody, from what I've been reading online, and I've read, there's a lot of articles and material out there on this case, and the practical effect of this case. It sounds like it's actually going to have a pretty significant effect because, at least in the Ninth Circuit, the denial of cert means that the Ninth Circuit's decision in Lusnick is binding law. And that means that if you're banking in the Ninth Circuit, any state within the Ninth Circuit, you have to pay the 2% interest. Now, what's interesting is that Minnesota came up in a lot of these articles because Minnesota apparently has a statute that requires banks to pay 3% interest on escrow, which I didn't know, which is interesting. But I don't know if banks just ignore that or as a practical matter how that works. But this one was one that I think a lot of people expected to be accepted. The other interesting angle on the Lusnick one is that, so it's a preemption case, but it also implicates the deference, like the Chevron deference questions, because the OCC had a regulation that was directly on point and had interpreted the regulation directly on point with guidance that said that the National Banking Act preempts the state statutes that require payment of interest on escrow amounts. And the court in the Ninth Circuit just didn't care and didn't follow that, didn't give any deference or anything. So the OCC said, yeah, it's preempted, and sounds like had a regulation to that effect. I don't know if they can really, I've never really heard of a regulation like that a agency would issue, but that's another interesting angle to it is a lot of people, because that's another, seems like hot issue right now that's in the Supreme Court is deference, like Tim was saying. So that seemed like another reason why this one had a really good chance of cert being granted, but ultimately it didn't. This one I think is really simple too, and then I think I'm done after this one?
Yep.
All right. So here we've got, this is Thompson v. JP Morgan Chase. This is another one that, even though it's not really up at the Supreme Court, it's one that I think that I've heard that the banking clients have told me that they're paying attention to. And actually, I think it's a fact pattern that I've seen before in a couple other cases, but it's always interesting to see how different courts deal with this problem. I think especially if you get federal court decisions, I think most of the decisions I've seen are state court decisions. And this one went up to, I think, the First Circuit. It's a Massachusetts case, is where it originated. I think it was removed to federal court. It's basically just a simple wrongful foreclosure case. And at issue is certain paragraphs from the mortgage that required a particular quality of notice as an antecedent or condition to being able to foreclose on the loan through the power of sale. And paragraph 19 of the mortgage describes a right to reinstate after acceleration, including certain conditions and time limitations related to that right. Most importantly, this provision only allowed a reinstatement payment 5 days before the sale of the property. And so if you didn't cure 5 days before or earlier, then you weren't going to have the right to cure anymore as the mortgagor. Paragraph 22 had some notice requirements. Prior to accelerating payment, the bank has to provide accurate notice specifying the default, the action required to cure the default, a date not less than 30 days from the date the notice is given to borrower by which the default must be cured, and must state that the failure to cure the default on or before the date specified in the notice may result in acceleration of the sums secured by the instrument and sale of the property. So the district court, I think it was Judge Zobel in Massachusetts, recognized that Massachusetts courts require mortgagees to comply strictly with two types of mortgage terms. And I think that this is pretty common. I've seen this in a lot of different states, that there's there's obviously, I mean, Minnesota has strict compliance requirements with foreclosure that you have to strictly comply, most states do, with power of sale, the states that offer it, that allow it. First, terms, quote, directly concerned with the foreclosure sale authorized by the power of sale in the mortgage, and terms prescribing actions the mortgagee must take in connection with the foreclosure sale, whether before or after the sale takes place. Those there must be strict compliance with those types of terms. So Chase had to strictly comply with paragraph 22, but the notice that was given to the borrowers did not inform them that they had to cure at least 5 days before the sale. It said, quote, you can still avoid foreclosure by paying the total past due amount before a foreclosure sale takes place. And so it didn't articulate that 5-day window, or deadline, threshold, whatever the word. So that's, the district court in Massachusetts found that was good enough, basically. And the First Circuit, I think it's pretty simple, it just said, good enough isn't good enough, that it has to be strict and perfect. And this is not strict, perfect compliance, that they need to articulate the 5-day rule. So it's real, I mean, I don't think it's necessarily a earth-shattering decision. I think it's consistent with probably what we already understand about foreclosure requirements. But it's an interesting example because it got to the federal appellate court level. And I think that's probably why it's pretty rare and why some of our banking clients had been onto it and were watching it. Yeah.
What did they remand back for? I mean, clearly they did not.
It was a motion to dismiss. So it's whether or not they stated a claim for which relief could be granted, and then they remanded for further proceedings consistent with the instruction that they had stated a claim. So it was, presumably it's just gonna go on. There's still elements, obviously, like causation, things like that might be at issue. And so I think that's kind of what it is. All right.
So the last topic we're going to talk about is the Supreme Court and its Federal Arbitration Act decisions. It granted 3 cases related to the FAA this past term. And historically, over like the past 10 years, all FAA cases have kind of taken a similar path on the way to the Supreme Court, which is that a court of appeals issues some sort of decision, saying that there's a right to litigate in court as opposed to arbitration, or a threshold decision is to be one for the court to decide rather than the arbitrator, or that there is kind of a right to, class action relief even in the arbitration context, some sort of kind of pro-court or pro plaintiff decision. And then it goes up to the Supreme Court, and in a closely divided 5-4 split, with Justice Kennedy joining the conservatives, it would get rejected and reversed, and a pro-arbitration decision would be issued. So there was no real reason to think that trend would change with Kennedy retiring and now Kavanaugh taking his place. And the first case that the court issued its holding in, New Prime Inc. v. Oliveira, was one where Kavanaugh hadn't actually been confirmed yet when oral argument was heard. So he wasn't on the court at the time. And this is one where similarly, you had the lower court issue a pro-plaintiff decision, and the thought was that this could even result in like a 4-4 split and the case going back down. Instead, you had a unanimous opinion that said that there's a right to litigate in court, and it was issued by Gorsuch. So it was kind of a surprising result. The holding and issue in this case was that the Federal Arbitration Act in Section 1 has this exclusion for disputes involving the contracts of employment, is the key statutory language, of certain transportation workers, where they're exempt from the FAA's arbitration provisions and can instead litigate in court. Here you had people who were in the transportation industry, but under their contracts, which had arbitration clauses, they were listed as independent contractors. And so what you had is you had the companies arguing, well, contracts of employment is referring to an employee relationship, so the exclusion is pretty narrow. Independent contractors aren't employees, and therefore they're not excluded from the FAA. They're subject to arbitration, while the independent contractors were saying, well, these are still contracts of employment. And the unanimous opinion really rested on the statute's text. And I think if there's one takeaway, it's that, is that the plain text of the statute is going to control and is where different members of the court can kind of reach agreement. Here, Gorsuch said contracts of employment is different than saying employee or employer. And he then went through kind of this historical analysis and said, certainly at the time the FAA was passed, at kind of the turn of the 20th century, the whole distinction that is common now in modern law didn't exist then. So you had a unanimous opinion that contracts of employment do include independent contractors, and thus the exclusion does not apply. A unique case where, again, a pro-arbitration decision wasn't issued. The next case, Henry Sheen, Inc. v. Archer and White Sales, is a pro-arbitration decision, but is also unique compared to kind of the history over the past decade, in that it was also unanimous. Here you had Justice Kavanaugh writing his first opinion for the court, and what was at issue here was, it's a common principle in arbitration law that while the threshold question of arbitrability is one for the court, the statute permits that the parties by contract can agree that instead that threshold decision can be one for the arbitrators, and if so, and if that's in the contract, that should be enforced. Some circuits had employed what's called this wholly groundless exception, where they said if the argument that as a threshold matter that should be interpreted by the arbitrator is wholly groundless, well, then the court can take up the question of arbitrability on its own rather than sending it to the arbitrator. Here, Justice Kavanaugh, with the whole court behind him, said, that's not what the statute says. The statute says that the parties can agree by contract that these issues threshold issues can be decided by the arbitrator. There's nothing in the statute giving rise to a wholly groundless exception, and therefore it just doesn't apply. The third case is one that court watchers are saying could go back to kind of the old 5-4 splits. It's the case Lamps Plus, Inc. v. Varela, hasn't been decided yet. And this involves the question of whether the Federal Arbitration Act forecloses a state law interpretation of an arbitration agreement that would authorize class arbitration based solely on general language commonly used in arbitration agreements. So the issue here, I think, is California, like other states, has principles of contract interpretation where any sort of like ambiguous provisions are supposed to be interpreted in favor of the individual rather than the company that drafted the language in the first instance. So when you have arbitration language that doesn't say anything one way or another about class arbitration, as it's generally been interpreted under federal common law, you need magic language to make sure that if you're going to be able to proceed in class arbitration. But the question is, what do you do when you have state contract principles that instead say, well, any ambiguity goes to the individual? So that's the third issue before the court. Remains to be seen how they'll come out. Unless there are other questions, that's it. Refreshments in the back.